All right, hold on a second. We were not streaming live. All right, we are now. Okay, go ahead. Was there a response from the people regarding that?
Yes, Judge, I have no objection to that. So as long as Brother Counsel is fine with Your Honor writing in, outside of picking up his children, that's fine with the people.
Okay.
No objection, Judge. Thank you.
All right, so Mr. Kuna, you're just gonna go to that location in order to pick them up, not to visit, correct?
Yeah, no, nothing like staying, just there to get them and leave. That's it.
Okay, so the court is gonna add, per the parties, Mr. Cooner is allowed to pick up one child or more than one?
I have two.
His children at the location may not remain at the location. Okay, I wrote that on the plea form. Anybody have any objection to that?
No, Judge.
None, Your Honor.
Okay, Mr. Kuna, did you sign this form or did your attorney sign on your behalf?
I believe he signed on my behalf.
Okay, all right. So in signing this form, you understand that you have given up certain rights, and I'm gonna go over those briefly. I understand your attorney went over them, but we have to go over them on the record, okay?
Okay.
All right, you give up the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question the witnesses against you, to have the court order any witnesses you have for the defense to appear at trial, to remain silent during the trial, to not have that silence used against you, or to testify at the trial if you wanted to. Do you understand you give up all those rights?
Yes, I do, ma'am.
If your plea is accepted, you've given up any claim that the plea was the result of promises or threats that were not disclosed to the court at the plea proceeding, or that it was not your own choice to enter into the plea. Do you understand you're giving up that right?
Yes, I do, ma'am.
Also, if your plea is accepted, you may be given up the right to appeal issues that will otherwise be appealable if you were convicted at trial. And any appeal from conviction and sentence will be by application or leave to appeal, not by right. So what that means is, Mr. Cooner, if you have an issue surrounding the circumstances of this plea and sentence, you have to ask the Michigan Court of Appeals to review that. It's not automatic because you took a plea. If you have been convicted at trial, it would be automatic. So do you understand you give up that right?
Yes, I do.
Knowing and understanding all the rights we just went over, is this your wish to give up those rights and plead guilty today?
Yes, ma'am.
Other than the plea agreement, has anyone promised you anything else to get you to plead guilty?
No, ma'am.
Has anyone threatened you or coerced you in any way to get you to plead guilty?
No, ma'am.
And are you in fact pleading guilty of your own free will?
Yes, I am.
Are you currently on probation or parole?
No.
Okay. All right. Madam Prosecutor, please state voir dire the defendant for the elements of the charge.
Okay, Judge, no problem. If at some point my computer is freaking out, I'm not sure why, but if I leave for any reason, that's why. Okay, Mr. William Joseph Cunner, bringing you back to the date of June 13th, 2020. Did you find yourself at the location of Franklin Square Apartments located at 28940 Lancaster, Lancaster, in the city of Livonia?
Yes, I did.
Okay, and is that in the county of Wayne, state of Michigan?
Yes.
Okay, and on that date and at that location, did you go inside a shed?
Yes, I did.
Okay, and did you go inside by opening the door?
Yes.
Okay, and when you went inside that shed, did you have the intent or mindset that you were going to steal an air conditioner or something inside?
Yes.
Okay. And did you actually take that air conditioner that was inside of that shed?
Yes, I did.
Okay. Judge, I'm satisfied.
Did you have permission to do that, Mr. Cooner?
No, I did not, ma'am.
All right. Defense, are you satisfied?
Defense is satisfied. Yes.
Has the court complied with Court Rule 6.302?
Yes, Judge.
Court has, Your Honor.
The court finds that the defendant's plea is understanding, voluntary, and accurate, and will accept the plea of guilty. The defendant will be referred to probation department for a pre-sentence report. Mr. Cooner, you need to call probation. The number is 313.
Okay.
456.
456.
4600.
456 4600. Okay.
You need to call them once you get off of this call so they can set up an interview for you for your sentencing. Madam Clerk, what day will the sentencing be? May 14th. Sentencing will be May 14th at 9 o'clock.
Okay.
All right, thank you.
Thank you, Judge. Have a great weekend.
You too.
Ms. McCray,
Yes.
can you please, wait a minute, maybe not. Yes, will you please send me an investigation report?
Let me see if I didn't send, what, I'm sorry, can you tell me your name?
Vivian, Vivian Hill, Hill.
Okay, let me.
And 3R.
Okay, thank you.
You're welcome.
Okay, do we have the please from Bert? All right, thank you. All right, the court is now in possession of the plea form, settlement offer, advice of rights, notice of acceptance. For Bert. Do the parties have the PSI on Bert?
I
Yes,
do,
Your
Your Honor. We have reviewed it with my client and there are no changes, additions, or deletions except,
Hold on, I think the case hasn't been called.
oh,
All right, go ahead.
Recalling case number 20001650, the people of the state of Michigan versus Justin Burke. This is scheduled for sentencing appearances for the record, please.
Good morning again, Your Honor. Abigail McIntyre appearing on behalf of the people, P71143.
once again, Judge, John Knappman, P42983 on behalf of Mr. Burke.
Okay, and Mr. Burke, please state your name for the record.
My name is Justin Burke, and good morning.
Good morning. Mr. Burke, you agree to be sentenced over Zoom?
I do.
All right. Have all the parties had an opportunity to review the pre-sentence investigation report?
Yes.
Yes, Your Honor. One change since the report was compiled, Mr. Burke is no longer working at the place he's been working at since 2018, I believe. He's no longer there through no fault of his own. He was exposed to COVID. His job is to go to people's houses and work on their furnaces.
Hold on, Counselor. Just tell me where the change is. So where it says we're employed under personal history, he's no longer at HR Enterprise?
Right.
Okay. Court will strike. Any objection from the people?
None for the people, Your Honor.
And just by way of history, Judge, I mean, his boss wanted him to keep going to houses even though he had just been exposed to COVID. He didn't want to, and so he fired him. And
Okay,
so
does he have a
obviously that's
current-
not his fault.
Does he have Mr. Knappman, does he have a current employer?
He does not. It just recently happened.
Okay, that's fine. All right, the court struck that under personal history on the first page. I'm not sure if it's indicated anyplace else. If it is, you can let me know and the court will strike it. Any other additions, deletions, or corrections, defense? To the
No, Your
body of the report? Okay, Madam Prosecutor, any corrections, deletions, or additions to the body of the report?
None for the people, Your Honor.
All right, Mr. Burke, did you review the pre-sentence investigation report with your attorney?
Yes, Your Honor.
Is everything stated in the report true and accurate outside of the fact that we just changed your employer is no longer at our enterprise?
Yes, Your Honor.
Have the parties reviewed the sentencing guidelines in the sentencing information report?
Yes,
Yes,
Are there any corrections to the guidelines?
none for the people.
none.
Okay. All right, originally, Mr. Burke, Mr. Burke is defendant number one. Was charged with count one, children accosting for immoral purposes, which was four-year offense, as well as controlled substance delivery to a minor, marijuana, 8-year offense. And I believe that's it. Okay, and there was a plea reached in which he pled guilty to count two, controlled substance delivery to a minor, marijuana, which is an 8-year offense. The people agreed to dismiss count one, and there was a sentence agreement of defendants to serve 2 years on probation. Defendants shall complete sex offender treatment and counseling, substance abuse evaluation, and treatment. Do the people have anything further that they would like to say before the court imposes sentence?
Your Honor, the people just wish that the court would adopt the agreement reached between the defendant and the people. It's the people's hope that Mr. Burke receives the treatment he needs. The complainant in this matter was his relative, in my understanding, based on the pre-sentence investigation report and the impact statement, which is included in that from the victim, that it's caused a lot of stress and strain on family relationships, which makes a lot of sense. And, I hope he receives his treatment and is able to build back the relationship with his family. And the people wish that the court will adopt the plea agreement and the people move to dismiss count one.
Okay, any objection?
No, Judge, I'd only point out that Mr. Burke regrets this happened when it did. And he's bound and determined to continue to recover from his substance abuse issues.
Okay, Mr. Burke, do you have anything that you'd like to say to the court before the court imposes sentence?
Oh, no, Your Honor.
Okay, the court will follow the sentence agreement, a plea agreement, which is 2 years probation. There is 4 days jail credit, is that correct?
Yes,
You
Your
were
Yes.
Honor.
locked up 4 days? Yes,
Okay, all right, and the court will dismiss count one. Per the sentence agreement, the defendant must complete sex offender treatment and counseling and substance abuse evaluation and treatment. You must comply with the requirements of drug testing directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. You must not use or possess any controlled substance or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must complete outpatient or residential substance abuse treatment when you are referred by the field agent. You must perform 40 hours of community service as directed by the field agent. Was community service a part of this plea agreement?
it was not, Judge.
All right, the court is going to strike number 5. You must
Neither
not
was
drive a
number
motor-
6.
On mine, I have it as number 5.
Yeah, but I'm saying number 6 was not a condition either. I don't know
Oh,
if it's
I'm
called
sorry.
for in the statute, but I don't think you need to impose it as a condition of 6 months suspension.
All right, the people, are you aware of any reason why number 6 should be a part of this? That he's not driving a motor vehicle while his license is suspended? Mr. Burke, is your license suspended?
No, Your Honor.
Your Honor, I have no idea why that is included in there.
Okay, the court is going to strike number 6 as well. No objection from the parties, correct?
That's correct.
You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week unless engaged in an alternative program approved by the field agent. You must provide ongoing verification of employment or alternative program to the field agent. You shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission from the field agent. You must comply with the DNA testing and pay $60 fee. You must pay $68 state costs as ordered by the court. You must pay crime victims assessment in the amount of $130. You must pay court costs in the amount of $600. My understanding is Mr. Burke was just fired. Is that correct?
Correct, Judge.
So the court is going to reduce the court fees to $200. And you must pay $30 per month supervision fee and $60 a month. No, you're not on an electronic device. Is he on an electronic device?
No, Judge, he was for a year, but this court removed that for a while ago.
Okay, so that doesn't apply either. It is my duty to advise you that you have the right to request leave to appeal from the Court of Appeals to appeal your plea and sentence. If you are unable to afford an attorney to prepare post-conviction motions or perfect an appeal, this court will appoint an attorney for you as public expense and will provide that attorney with such portions of the transcript as that attorney may require to prepare the motions of an appeal. You are further advised that if you wish to file an appeal or motion, the request for the appointment of an attorney must be made in writing and filed with the clerk of this court within 42 days of today's date. Because you are on Zoom, the clerk here today will email the advice of appellate rights form to your attorney, who will forward it to you. Does your attorney have permission to initial the form on your behalf, acknowledging your receipt of the form?
Yes, Your Honor.
All right, that's the form that you must file with the clerk of this court within 42 days of today's date if you wish to appeal and need to have counsel appointed for you. If you do not wish to appeal, you do not have to send the form in. All right, Mr. Burke, you need to contact probation. That number is 313-456-4600.
Thank you, Your Honor.
Okay, this matter is concluded. Anything else from the parties?
Nothing for the
Oh.
people.
Thank you, Your Honor.
Thank you. Have a good day. Good luck, Mr. Burke.
Have a good weekend.
You too. All right. Who's ready?
Judge Baker, can we
Judge,
move
we're ready on
forward
Kyla
with the
Dean.
Hatfield? I'm sorry.
I'm sorry. What'd you say, Michelle?
We have the violation for Mr. Hatfield that actually was already resolved in 2019. So can we just go on the record with that and close it out?
Oh, okay. All right. Well, let's do that real quick.
Calling case number 1900545, the people of the state of Michigan versus Brandon Hatfield. This is scheduled for arraignment on violation of probation. Appearances for the record, please.
Good morning, Your Honor. If it pleases this most honorable court, William Hackett, P65962, on behalf of Mr. Braden Hatfield. Mr. Braden Hatfield has a brother named Brandon Hatfield. That's why I want to make this clear. It's Braden L.C. Hatfield that we're dealing with today, Judge.
Is that spelled B as in boy, R as in Richard, A, D as in David, E, N?
It is, Judge.
Okay, we're dealing with Braden Hatfield. Do you understand that, Ms. Shaw?
Yes, Judge.
Okay. Put your appearance on the record.
Lori Schoen, Department of Corrections.
Okay, what are we doing with this?
Judge, this matter was actually resolved back on 11/25/19 when the warrant was set aside. It was just never taken out of warrant status. So we would just ask that the case be closed out under HIDA.
All right, the court will close the case out under HIDA, and we need to make sure that it's taken off of warrant status. Okay, it is. All right, thank you. This matter is concluded. It's, Mr. Hatfield, is he, I'm sorry, Mr. Braden Hatfield, is he on the call?
Yes, I am here.
Okay, just state your name for the record, Mr. Hatfield.
Braden Hatfield.
Okay, so your matter is concluded and closed out under HIDA, okay?
No, it's not what we were doing here today.
That's what we're doing.
Oh, this
Say-
is what we're doing?
Say yes,
I believe
Mr.
your attorney has
Hatfield.
indicated
yes. Yeah,
what. Okay, do you understand what's going on, Mr. Hatfield?
yes.
Okay, have a good day.
Thank
Thank
you,
you.
Judge. Be safe.
too.
Everybody be safe.
You too.
Thank
All
you.
right,
Thank you. Bye.
goodbye. Who else is ready?
I'm ready.
Ready on
for
Dean.
a guilty plea on Martin Stewart, Your Honor.
Okay, so we have Dean and a guilty plea on Stewart.
Here
All
on
right.
Fickling, Your Honor.
I'm sorry?
Here, Attorney McWilliams on the Fickling matter.
Okay.
Standing
Are
by.
all the parties here on that matter?
I believe so. We have a new prosecutor on the case, Your Honor, that I'm not familiar with. I
Judge,
believe
it's me. It's Miss Hindling. I'm on Fickling and Stewart.
Okay, good. Good morning, Ms. Hindley.
Good morning. How are you?
I'm well. All right, let's call Kyla Dean.
Calling case number 20002545, the people of the state of Michigan versus Kyla Dean. This is scheduled for sentencing. Appearances for the record, please.
Good morning, Your Honor. Spencer Clayton, appearing on behalf of Miss Dean, P number 77302.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Good morning. And Ms. Dean, are you on the call?
Yes, good morning.
All right, please state your name for the record.
Kyla Dean.
All right. This is the date and time and place set for sentencing in this matter. Ms. Dean, do you consent to be sentenced over Zoom?
Yes.
All right. There was a plea agreement in this matter where the defendant pled guilty to charge 1, weapons carried concealed, which is a 5-year max, as well as charge 2, which was operating license suspended, revoked, denied, allowed. The defendant has a plea agreement to dismiss notice on count 2, withdraw notice to enhance, sentence on driving while license suspended. The people consent to HIDA on count 1 and 1-year probation with telephone reporting for 6 months if abiding by terms of agreement, must forfeit weapon to arresting agency, may not own, use, or possess a firearm during the period of probation, and any other terms or conditions set forth by the court. Did the parties have an opportunity to review the pre-sentence report?
Yes.
Yes, Judge. We find it to be factually accurate. No additions, deletions, or corrections.
All right, Madam Prosecutor.
Yeah, I have no additions or corrections or deletions either.
Okay. Ms. Dean, did you review the pre-sentence report with your attorney?
Yes.
Is everything stated in the report true and accurate?
Yes.
Okay. Have the parties had an opportunity to review the sentencing guidelines?
Yes, Judge.
Yes, Your Honor.
Let's see, let me go to the sentencing guidelines. Okay, the sentencing guidelines before the court are 0 to 3. Is that correct?
Yes.
Yes, Your Honor.
All right. Do the people have anything further they would like to say before I impose sentence?
Yeah, Judge, we would at this time move to withdraw the notice on count 2.
Okay. Any objection by the defense?
No, Your Honor.
Anything else from the people?
No, Judge, thank you so much.
Is there anything further you would like to say? Defense counsel, do you have
Yes.
anything? Mr. Chris, please mute your phone. Thank you. Defense counsel, do you have anything you'd like to say?
Your Honor, we're just asking the court to go along with the agreement, and that's pretty much what the report is saying. So I've spoke obviously with Ms. Dean about it. She understands what she needs to do. And I think this is a good opportunity for her, Judge.
Okay. Ms. Dean, is there anything you'd like to say to the court before the court imposes a sentence?
No, Your Honor.
Okay. All right, the court is going to follow the sentence agreement. Place the defendant on probation. For 1 year with telephone reporting after 6 months if abiding by terms of the agreement. The court is going to place the defendant on HIDA. The defendant must forfeit the weapon to the arresting agency. You must not own, use, or have under your control or area of control a weapon of any type or any imitation of a weapon. And you must not be in the company of anyone you know to possess these items. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week. Ms. Dean, are you working?
Not right now because of the COVID. I was getting the unemployment through my job. I was working for them since 2018.
Okay, so are you laid off by them or?
Yes, I'm on
Go
furlough.
ahead.
I'm on
You're on
furlough. I'm
furlough.
laid off.
Okay, so technically you do have a job, correct?
Mm-hmm.
Oh,
I'm just
is
not
that a
accumulating
yes?
any hours. Yes, I'm just not accumulating any hours because of the COVID. They didn't open back up yet.
Okay, and where do you work, Ms. Dean?
Continental Services for Troy, Michigan.
Okay. All right, so I understand what the situation is. So on here just says minimum of 30 hours per week. I understand that you are furloughed. Unless engaged in the alternative program approved by the field agent, you must provide ongoing verification of employment or alternative program to the field agent. You shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission from the field agent. You must pay $121 in state costs. You must pay a crime victims assessment amount of $130. You must have to pay court costs in the amount of $1,300. Ms. Dean, I'm going to reduce your court costs to $300. Okay?
Yes, thank you.
This says you must not drive without a valid driver's license. Do you have a valid driver's license?
No.
Okay, well then you cannot drive until you get one.
Mm-hmm.
You must clear all traffic warrants within 90 days of being sentenced to probation. You must pay $30 per month supervision fee. I believe that is it. It is my duty to advise you that you have the right to request leave to appeal from the Court of Appeals for your plea and sentence. If you are unable to afford an attorney to prepare post-conviction motions or perfect an appeal, the court will appoint an attorney for you at public expense and will provide that attorney with such portions of the transcript as that attorney may require to prepare motions on the appeal. You are further advised that if you wish to file an appeal or motion, the request for the appointment of an attorney must be made in writing and filed with the clerk of this court within 42 days of today's date. If you will receive, or the clerk here will email the advice of appellate rights form to your attorney, who will forward it to you. Does your attorney have permission to initial the form on your behalf, acknowledging your receipt of the form? Ms. D?
Yes.
Does your attorney have permission to acknowledge, to initial the form on your behalf?
Yes.
All right. That's the form that you must file with the clerk of this court within 42 days of today's date, if you wish to appeal and need to have counsel appointed for you. If you do not wish to appeal, you do not need to send that form in. You must contact probation today. That number is 313. You have this right, Ms. Dean?
Yeah, I'm putting it right now.
Let me know when you're ready.
Write this number down. 313
456
456
4600.
4600.
Yes. You have that?
Yes.
Okay, Ms. Dean, we're concluded. Anything else from the parties?
No.
No, Your Honor. I did put my email in the chat.
Okay. Ms. Dean, good luck to you.
Okay, thank you.
Thank you. Bye-bye. All right, we're going on to Stewart. Martin Stewart.
Ready, Your Honor.
Okay. The court, well, we have to call the case, sorry.
Calling case number 19-000598, the people of the state of Michigan versus Martin Stewart. This is scheduled for a pretrial appearances for the record, please.
Good morning, Your Honor. Tara Hindelang on behalf of the people.
And good morning, Your Honor. David Cripps, P34972, appearing on behalf of Martin Paul Stewart. He's joined us by Zoom. We have absolutely no objection to proceeding by Zoom today.
All right, Mr. Stewart, state your name for the record.
Martin Paul Stewart.
All right, good morning, Mr. Stewart. Good morning, Mr. Cripps and Ms. Hindelang.
Good morning.
I understand that the parties have reached a plea agreement. Madam Prosecutor, please state the name of the terms of the agreement.
Yes, Judge, in exchange for a guilty plea to count 3 domestic violence, as well as a charge of assault and battery, the people would agree to dismiss counts 1 and 2, as well as withdraw the notice to enhance sentence habitual third offense notice. There would be a sentence agreement to 2 years probation, no assaultive contact with the complainants, batterers, counseling, and any other terms set by the court.
Please give the statutory maximums of the DV and the A and B, Madam Prosecutor.
The domestic violence charge is a 93-day misdemeanor, and A and B is a 90-day misdemeanor.
Okay. Mr. Martin, please unmute yourself. Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth?
Yes, ma'am.
All right, and you wish to enter into a plea agreement today based on the recitation just given by the prosecutor?
Yes, ma'am. As long as it's non-reporting probation.
I told Mr. Stewart, Judge, that that's something in your consideration as sentencing.
Yeah, this is 2.5 years. This is 2.5 years ago, by the way, Judge.
Mr. Stewart, just listen to the judge's questions. Please don't interrupt, okay?
Yes, sir.
Mr.
Sorry,
Stewart,
Your Honor.
It's 2 years probation. I'm not gonna tell you that it's non-reporting.
Oh, okay.
This is a sentence. My understanding is this is a sentence agreement by the people, correct?
Yes, Judge, it would be a sentence agreement. We did not discuss whether probation would be reporting or non-reporting.
That's correct, Your Honor. And
Hold on. First of all, I'm gonna check sentence agreement because it's not checked. Does anybody have an objection to that?
no objection.
All right. So there was no discussion about whether he could report or not report. And do the people have any thing they want to say with respect to that?
I would wait until there's been the pre-sentence investigation to see what they say. My concern is that I understand that this offense was a long time ago. That can't be helped. There's a pandemic. Mr. Stewart has been charged for a long time as well. There was no delay in charging or anything like that. I understand that to some extent he's been compliant with the conditions of
Every
bond. Nonetheless, this is a pretty large reduction in charges. So I would want to wait to see what the probation department evaluates during their PSI preparation before I place any objection or consent on the record for that.
All right, Mr. Martin, the court has also not seen the pre-sentence investigation, so the court is not going to promise you that this is going to be 2 years non-reported. So what do you want to do?
Your Honor, I'm going to accept, but I also would like to say something in regards to that, if I may.
Well, go ahead.
Well, we've spoken to the court. I'm sitting here with my ex-wife, I'm sitting with my son. We've spoken to the court to try to get this resolved. So we've moved forward in our life from this incident. I mean, for 1.5 years now. And we've tried to tell the court this. We've tried to call them and contact them to get this resolved. And that's why the reduction has been made. I have been free and clear for 2.5 years on bond, never had one incident, reported every time I've ever had to. So I've done everything the court has asked me to. I went through 3 judges, and I'm here to resolve this case and move forward. With that being said, I agree to whatever needs to be done to move forward in my life and put this behind me.
Okay, Mr. Stewart. How far did you go in school?
I got like 1 class left, and it's in September, and I'm going to be a journeyman operator, heavy operating engineer.
My question, Mr. Stewart, is how far did you go in school? That's a
How far did
trade
I
school.
go?
I'm asking how far did you go?
Oh, I graduated high school. Yes, I graduated high school.
Okay.
I did not go to college. I went to 1 year in college, and then I joined the apprenticeship. I joined a union in 20, and then I worked there, and I joined another one. I joined apprenticeship 3 years ago.
Okay, good. So you got a great career ahead of you.
Maybe.
Right.
We'll see.
You will. Did you read it? Do you read and write the English language? I'm sure you do.
Yes, ma'am.
All right. Do you understand what's happening here today?
Yes, Your Honor.
Okay. And I have in front of me a settlement offer, advice and rights notice of acceptance, in which the people have indicated you can plead to count 3, domestic violence, which is a 93-day max, and count 4, assault and battery, which is a 90-day max. The people have agreed to dismiss counts 1 and 2. There's a sentence and withdraw the notice of habitual third. There's a sentence agreement of 2 years probation, no assaults of contact, batterers, counseling, and any other terms set by the court. At the bottom, there are signatures. Mr. Stewart, did you sign this, or did you give your attorney permission to sign on your behalf?
Permission to sign on my behalf, Your Honor.
All right. And you discussed this plea with your attorney. Is that correct?
Yes, Your Honor.
And are you satisfied with your attorney's representation?
Above and beyond. Yes, Your Honor.
Okay. Well, I know that you went over the form with your attorney, but the court has to put it on the record. By pleading guilty here today, I'm going to indicate what rights you're giving up, and you can let me know that you understand that. By pleading guilty, you give up the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question the witnesses against you, to have the court order any witnesses you have for the defense to appear at trial, to remain silent during the trial, to not have that silence used against you, or to testify at trial if you so chose. You understand you're giving up all those rights?
Yes, Your Honor.
All right. If the plea is accepted, you will be giving up any claim that the plea was the result of promises or threats that were not disclosed to the court at the plea proceeding, or that it was not your own choice to enter into the plea. You understand you're giving up that right?
Yes, Your Honor.
And finally, if your plea is accepted, you may be giving up the right to appeal issues that will otherwise be appealable if you were convicted at trial. So what that means is, and you have to ask for leave for the court. So by you taking a plea, if you have an issue later with any of the circumstances surrounding your plea and sentence, you have to ask the Court of Appeals to look at it. It's up to them whether they choose to do so. If you had gone to trial and were found guilty, it would be an automatic right. So do you understand that you're giving up that automatic review of the Court of Appeals?
Yes, Your Honor.
All right, knowing and understanding all the rights we just went over, Is it your wish to give up those rights and plead guilty today?
Yes, Your Honor.
Other than the plea agreement, has anyone promised you anything else to get you to plead guilty?
No, ma'am.
All right. And has anyone threatened or coerced you in any way to get you to plead guilty?
No, Your Honor.
And are you in fact pleading guilty of your own free will?
Yes, Your Honor.
Are you currently on probation or parole?
No, Your Honor.
All right. Madam Prosecutor?
Thank you. Mr. Stewart, I want to direct your attention back to December 22nd, 2018. Do you remember that day, sir?
Yes, ma'am.
And on that date and time, did you go to 22862, and then I'm going to spell for the court reporter's sake, the name of the street, Nadyne Street?
Yes, ma'am.
And was that in Brownstown Township in Wayne County?
Yes, ma'am.
And when you got there, was there someone by the name of Miss Diaz there?
Yes, ma'am.
How do you know that person?
She's sitting right next to me. It's my ex-wife.
You have a child in common?
Yes, ma'am.
And what's the child's name?
John Brian Stewart.
And was your child there that day as well?
He's sitting right next to me. And yes, he was there that day as well.
And on that day, when you got to that location, did you grab Miss Diaz by the neck?
No, ma'am, I did not do that day. And I
Did
wish
you
wouldn't have
assault,
said that.
if I could
Yeah.
interrupt,
Yeah.
Mr. Stewart, you agreed you assaulted her with your hands, isn't that correct?
Yes.
And that means that you
And
did
I'm
something.
sorry, and then, hold on one second. So, let's not use legal terms. What did you do, Mr. Stewart?
I came in and got in a physical altercation with my ex-wife over my son to go to a Christmas party for a family event that day.
Okay, I don't want the reason. I want to know, what did you physically do to her?
We wrestled around in the living room in front of our son, which was a bad mistake on my part.
Mr. Stewart, I'm not asking for your excuses.
I'm not giving you an excuse, Your Honor. I'm telling you, we wrestled in the living room.
Mr. Stewart,
Mr. Stewart, the court is talking, and you do not talk while the court is talking. Do you understand that?
Yes, ma'am.
My simple question is, how did you physically touch your wife? What did you do, ex-wife?
I didn't
you
even
push
touch
her?
her, to be honest, Your Honor. I didn't even touch her. I came in. That's their argument. I did not even touch her.
Okay, well, if you didn't touch her, it's not, how is it assault and battery? What did you do?
You know, that's a great
You didn't
question, Your
push
Honor.
her,
That's a
you
great
didn't do
question.
anything. Mr. Cripps,
yes, Your Honor.
can you order your client? Otherwise, the court is not accepting this plea.
Could I have a breakout room with him possibly?
Sure.
So we can have a good conversation between he and I about what's going on here?
And Judge, quite frankly, I'm concerned that the victim is sitting, both victims are sitting with the defendant right now in the same room.
Well, we've tried to call you and talk to your
Mr.
office.
Stewart, quiet till I talk to you before you blow this whole thing. Sorry, Your Honor.
That's okay. All right, you're gonna get an invitation in a second.
Thank you.
All right, we're gonna move on from this matter right now. Anything else ready?
Your Honor, I believe we're ready on the co-defendant case, Velasquez and Lara.
All right, good morning, Mr. Mazzy.
Sorry. And Mr. McWilliams and I are ready on Fickling.
I'm here, Your Honor.
Okay, Mr. Mazzy, who is your client again?
Your Honor, Maria Lara.
Can you spell that for me?
It's the last name is Lara.
Okay, I see it. Let's call Maria Lyra's.
Morning.
Good morning.
I'm here on Velasquez. That's the co-defendant for Lara. I don't know if he's in the waiting room. We've been trying to connect.
I haven't seen him. I've been looking and waiting and watching, and I haven't seen
No,
that.
there's nobody in the waiting room. This matter has a co-defendant?
Yes, Velasquez.
Well, we need to, who's the attorney? Is,
We
so
have
the
we just
co-defendant isn't here, nor the attorney?
I'd rather proceed.
Sorry, Judge, I couldn't hear what you were saying.
I said the co-defendant isn't on Zoom, nor the attorney?
Nope.
The attorney is on Zoom. Mr. Godwin is his attorney.
Oh, okay. Mr. Godwin, where's your client?
I'm not sure.
He's logged on right now.
Excuse me.
Stop, Ms.
Oh,
Laura,
there he
please
is.
don't talk. Ms.
Thank
Laura,
you.
mute your phone.
Sorry.
Okay, I'm sorry, Mr. Godwin. Mr. Godwin, your phone is muted now.
Mr. Velasquez is with us now, so.
Mr. Velasquez, are you on the call?
Yes, Your Honor.
Okay, all right, go ahead, call the vote.
Calling case number 2000172901, the people of the state of Michigan versus Maria Lara. This is scheduled for a pretrial, and also case number 2000172902, the people of the state of Michigan versus Miguel Velasquez. This is also scheduled for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Good morning, Your Honor. Romy Mezzi, P68245 on behalf co-defendant Maria Lara.
Sean Godwin, P74500 for Miguel Velasquez.
All right, and Ms. Lara, now put your name on the record. You're muted.
Unmute Maria Lara.
Maria Diana Lero.
All right, good morning, Ms. Lara. And
morning.
Mr. Velasquez.
Miguel Velasquez.
All right, good morning, Mr. Velasquez.
Good morning.
Okay, good morning to both counsel. The last time we were here, there was an offer put on the record. So where are we now?
Judge, we are unfortunately unable to move forward unless both defendants plead guilty to the plea offer. And I do, regret that for brother counsel, Mr. Mezzi. But I did talk to my supervisor, and we're just on it. We're unable to do that at this point. We have submitted, I've submitted jury trial readiness checklist, witness list, and Mr. Mezzi has submitted his witness list. And so that's where we're at this point.
Ms. McCray, you said you submitted the jury trial readiness form?
Yes, I e-filed on both defendants, and then I had to file an amended on co-defendant 1 because I had written the wrong name.
Do you see that on Odyssey? What is it? The jury readiness form. When did you e-file it, Ms. McCray?
I believe that was, let me check. I refiled the amended one yesterday. Let's see, that was on the 12th. I filed the witness list. And then I think yesterday I did the preliminary instructions.
Okay, hold on one second. I have did yesterday. I have what I have in the file, defendant's witness list, so it hasn't been pulled off, so it should be there. Okay.
And Your Honor, for the record, I did receive Ms. McCray's filings.
Okay, so I'm waiting for it to be pulled off now. Yeah, that's it. That's it. Yes, that's it.
Mr. Velasquez.
Hold on one second.
Yep.
And she also filed a witness list. So I need that as well.
Where's my lighter?
Miss Lara, you can mute your phone.
Okay.
Same for you, Mr. Velasquez. Okay, thank you. All right, the court is in receipt of the people's proposed preliminary jury instructions for element of the crimes as well as the jury trial readiness checklist. I need the people's witness list too. Yes. I only have a defendant's witness list for Miss Laura. Is there a witness list for Mr. Velasquez?
Not at this time, Your Honor. We filed a second motion to compel discovery last Friday and submitted a precipice for it to be heard today.
Okay. Hold on 1 second. Let me look in my information that was given. I think I saw it. I did. I read it last night. All right, so my understanding is there's an issue about a video which per defense's motion to compel discovery, second motion to compel discovery, has been indicated to him from the people or from the police department does not exist. Is that correct, Ms. McCray?
Yes, Judge. So I just received the brother count, Mr. Godwin had asked for a memo from the city of Lincoln Park saying they didn't have the the video, and I just received that memo about a minute ago. So I'm just trying to read it. There is no, so in this case, there's no audio or video, but there is a video from the co-defendant's OWI arrest the next day. And he said he mailed that to me. So I will obviously get that out to brother counsel. But I'll just forward it to all parties. And
yes, just forward the memo to them. And you said, and now it looks like there's still a video that the defense does not have.
Yeah, I would have, yes, it was,
Okay, that tells me we're not trial ready. So that being the case, then we have another issue of a witness that the defense is indicating has not been produced, Mr. Austin Hamrick. What's going on with that, Madam Prosecutor?
Yeah, we're still trying to get in contact with him, Judge. And so we're gonna, as soon as we're able to get in contact with him, we will try to make him available.
Okay, so brother counsel, to Madam Miss McCray, they're trying to get a hold of him. I mean, they've got to find him in order to make him available to you. It doesn't look like he's even endorsed on their witness list. So they can give you what they can give you, but if they don't have any more information than what they have,
Right.
They can provide you with his address based on the court rules. If you can't find him, Madam Prosecutor, court rules require that you give them the address. Maybe defense's investigator can find him. I don't know, but I understand that if the people can't reach him, then of course they can't make them available for you. But what they can do is give you an address. All right, Madam Prosecutor?
Judge, the people's position is that this is a 17-year-old at the time of this offense. And so I don't feel comfortable giving his information out to the defense attorney in this case. I don't, and I've spoken to my supervisor about it, Mr. Cobb, and he stands by my decision to, I do not feel comfortable.
Because he's a juvenile?
Yes, he's not anymore, Judge, but at the time of this offense, he was 17 years old.
Okay, but he's not 17 now.
That's correct.
He's an adult now. So the court is ordering you to give him the address.
Okay, Judge, I just need a...
Per the court rules.
Okay, I just need an order from you, Your Honor.
All right, the defense can provide an order, the court will sign it.
Will do.
If he was still a juvenile, I can understand that, but he's an adult now. All right, so this case is not trial ready. So I'm going to give the parties, how many matters do we have on May 14th? May 14th. Okay, we'll be back pre-trial on May 14th. By that time, hopefully everybody will have discovery or either have an indication why they don't have discovery. And hopefully maybe Mr. Godwin will be able to find this one witness that he's looking for. Anything else from the parties?
But I would just ask for, I guess, a protective order so that that Mr. Godwin doesn't share that information with his defendant.
Oh, for sure. We'll give you a protective order, but you still need to provide him with an address. None of that information is, a defendant, whatever the defendant gets from the prosecutor's office should be blacked out anyway. So he shouldn't be getting an address. All personal information, date of birth, that kind of stuff should be blacked out when it's turned over. But in this particular case for a witness list, he needs an address.
Okay, Judge. I just need an order for my file and a protective order, please.
All right,
That's
Mr.
fine.
Godwin indicated he's gonna do an off order.
That's fine. We're gonna send an investigator. The defendant doesn't need it, so.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Thank you.
All right, Mr. Velasquez and Mr. Lara, you all, we are concluded for today. We'll be back on May the 14th, okay?
What time? 9 o'clock?
9 o'clock.
9 o'clock.
Okay,
All right,
9
thank you. Have a good day.
Thank you. Have a good day, ma'am.
Thank you. You too.
All right.
Thank you.
Are we ready on Stewart now, Mr. Chris?
We're ready, Your Honor.
All right, let's try this again.
Okay. Ms. Schoen,
Yes, Judge.
what is your P number?
Oh, that's not me, that's the clerk, Ms. Shawn. Ms. Shawn is not an attorney, she's probation.
Oh, she's probation. Okay. All right. Thank you.
All right, recalling case number 19-000598. People of the state of Michigan versus Martin Stewart. Mr. Stewart, you are still under oath. And we were in the middle of taking a plea from Mr. Stewart, where we seemed to not be able to make out the elements of the charges. Mr. Cripps?
Yes, Your Honor. Could I interrogate my client on the record, please?
Sure.
Is that okay with you, Ms. Hindelay?
Ms. Hindelane, we can't hear you.
Oh, that's okay with me.
Thank
Okay,
you.
go ahead.
Mr. Stewart, back on the date of December 22nd, 2018, at 22862 Nadine Street in Browntown Township, County of Wayne, did you come into contact with Lorraine Diaz?
Yes, sir.
And was she the mother of your child?
Yes, sir.
Did you grab Ms. Diaz against her will with your hands?
Yes, sir.
And you grabbed her by her shoulder and physically, intentionally pushed her without her will. Is that correct?
Yes, sir.
And at the time you were in a relationship with each other. Is that correct?
Yes, sir.
Does anybody think of anything else we should ask?
The second, the A and B count relates to the child.
After you had a physical assault in relation to Ms. Diaz, did you pick up your son, John Brian Stewart?
Yes, sir.
And when you picked him up, did you begin to run as fast as you could through the door of the house with your child in your hands?
Yes, sir.
And by doing that in the fashion you did it and how you did it so quickly and grabbing him and running, did you know that under those circumstances, it could pose an unreasonable risk of physical harm to him by running as fast as you did?
Yes, sir.
All right, are you all satisfied?
Yes, I'm satisfied.
Thank you. I am too, Your Honor.
Okay, has the court complied with court rule 6.302?
Yes,
Yes,
Judge.
you have.
The court finds that the defendant's plea is understanding, voluntary, and accurate, and will accept the plea of guilty. The defendant will be referred to probation, and that number, Mr. Stewart, do you have something to write the number down?
Yes,
I'll write
ma'am.
it down and I'll write it down and text it to him, Your Honor.
Okay, that's fine. The number is 313-456-4600. Please contact that number today, Mr. Stewart, so you can be interviewed, and we'll be back for sentencing. When is sentencing, madam?
May 7th.
May 7th at 9 o'clock.
I'll call them right now.
Okay, thank you. This matter is concluded.
Thank you, Your Honor.
Thank you.
Thank you, Ms.
Thank
Ingerland.
you. All right, Feekling. I think I have Feekling up here.
Ready, Your Honor.
All right. Yeah, I do.
Calling case number 1900561, the people of the state of Michigan versus Darren Finkling. This is scheduled for a competency hearing. Appearances for the record, please.
Good morning, Your Honor. Tara Hindelang on behalf of the people.
And good morning, Your Honor. Attorney John McWilliams, P17-565. Mr. Fickling is here right behind me, present at my office, Your Honor. You have two matters up before you, Your Honor.
Hold on one second. Hold on one second, Mr. McWilliams.
Yes, ma'am.
Mr. Feekling, are you here?
Raise your,
Can't see Mr. Feekling. All right, Mr. Feekling, state your name for the record, please.
Darren Noel Beckley.
All right, the court sees Mr. Feekling is in Mr. McWilliams' office.
thank you.
Okay, what are we doing today?
Your Honor, at this particular time, you will note that long ago we filed a motion with regard to the issue of a one, let me get the,
On-scene identification of Mr. Feekling.
we're asking
Weren't we
for
supposed to be having a hearing? Weren't we supposed to be having a hearing on this?
to be set by the court, whatever the schedule would be in person.
Oh, this is in person. You want it in person?
That's correct.
All right, let me see let me check with my JA. I believe this was probably already sent to court administration. Hold one second.
I'm sorry, Judge, before you do that, can I ask a question?
Sure.
At last, I knew, I am new to the file. The defendant was out for competency and I don't know whether the court has ordered that he's competent to stand trial, which would make doing a hearing now not possible. I saw that Mr. McWilliams also filed an objections to the report and conclusion of the Forensic Center on the issue of his competency to stand trial.
Hold on, Ms. Cinderlang. I wasn't about to do anything. I'm checking to see if anything was sent regarding an in-person hearing, not that we're doing the in-person hearing. So hold on one second. And I have to check to see Mr. McWilliams, did we deal with the competency report when we were here the last time?
No, Your Honor, actually the competency report is just new and it has been just recently received, giving rise to my objections.
All right, so the court did not receive didn't have the competency report the last time we were here.
Correct.
Okay, hold on one second. Okay, all right. So I understand Ms. Hindelang is new to the file. We just received the competency. I understand, Mr. McWilliams, that you have an objection to the report, but the report is what it is. You can always ask for an independent, but at this point,
and I wish you have.
The court has received a report dated March 31st, 2021, regarding Darren Noel Fickling. This report is authored by Rebecca Liston, Liston, LMSW, clinical social worker, certified forensic examiner, dated 3/31/2021. And the based on the opinion of the examiner, overall based on the weight of the available information at the time of this report and the defendant's presentation at the time of the current evaluation, Mr. Fickling appeared capable of understanding the nature and object of the proceedings against him and assisting in his defense in a rational manner. It follows, although the ultimate decision in this matter depends on the judicial determination, it is the opinion of this examiner that Mr. Fickling was competent to stand trial at the time of this evaluation. Has everybody received that report from?
Yes,
Ms.
Judge.
Whitson?
I have acknowledged that and along with that, filed written objections to it previously filed before today, before the court, requesting the appropriate hearing. We've already contacted and made arrangements for independent evaluation of Mr. Fickling, making possible the request that you sign an order being able to transmit the forensic center's reports and et cetera to the independent examiner, of which I've already secured MIDC funds for.
Okay, so just to make sure that the court is understanding, Ms. McWilliams is objecting to the conclusion of this report and is requesting to have an independent done. Is that correct?
That's correct.
All right. And you already have an examiner for that independent, is that correct?
I do, and the funds approved.
Okay, and is there a date already set that Mr. Fickling will see that examiner?
No, the person has to receive the court order allowing him to receive the materials from the forensic center, and then he has to get it. It's quite, I'm sure, quite voluminous, and you'll probably need 3 or 4 weeks to examine it and then examine Mr. Fickling.
Okay, the
Yes,
court will
yes.
order that the examiner be given the materials needed to examine Mr. Fickling. Oh, no, that's
I'll
not
present
right.
that order. I have an order prepared, Judge, if I could
That's
fact.
fine. Send that to the court and then the court will sign it. Hold on one second.
Thank you.
Don't worry about it. Mr. Wick Williams. Okay, so present that order, the court will sign it.
Thank you.
And then we still have to put a date in.
Yes.
So I am just going to give a date a ways out.
90 days.
Yes, let's do 90 days.
We're looking at July the 23rd.
That would be the date of our in-person
No,
hearing
No.
on confidence.
No,
we're waiting for that competency hearing
competency,
to come back from your independent.
right. You have to get that first.
Okay, we'll get the reports on that at first. Is that what you're saying?
Correct. We need to come back on that date to make sure we have everything from your independent.
Thank you very much. I understand that now.
Okay, so that would be, what day is that?
July 23rd.
July 23rd at 9 a.m.
Judge, may I ask, the last time this was adjourned, I wasn't sure if there had been a prior referral to the Forensic Center for criminal responsibility. There's a note in the file that indicates that the court had not, or that the parties had not received the criminal responsibility, but I don't know if that's a typo and it should have said competency.
What was it referred for? That, Madam Clerk is gonna check and see what it was referred for, because I would not have been the judge that probably referred it. Why do they have it?
Competency evaluation and competency criminal responsibility.
Yes,
What is her question?
she wants to know, was it also referred for criminal responsibility?
It says here, yes,
And what date was that?
August 7th, 2019.
Okay.
August 7th, 2019, and we've never received a criminal responsibility report?
I don't know if the parties have. I don't believe that the criminal responsibilities are sent to the court. So I can check, and if there's an issue, I will contact Mr. McWilliams and contact the court.
My
Yeah,
information is, Your
that
Honor,
is an issue.
criminal
Mr. McWilliams,
criminal.
Mr. McWilliams, were you ever sent a criminal responsibility?
Your Honor, the file is rather voluminous, but my experience is that the criminal responsibility report is never sent to the court. I may have one, and I just can't recall it.
Okay, Mr. McWilliams.
I don't see
can
that.
You check, because the court does not have a criminal responsibility in its file. So if you have one, then we need to have a copy of it. Otherwise, we're gonna have to contact the forensic center because it should be here if it was referred.
Your Honor,
Yes,
respectfully, I understand that as a matter of course, criminal responsibility reports are not in the court file.
I agree with Mr. McWilliams'
Mr.
assessment.
McWilliams, hold on. I know these reports are not being kept in the court file, but the court still has to have the reports. You understand what I'm saying, Mr. McWilliams?
I hear you, Your Honor, and I understand, and I'm going through the
What
file.
I'm telling you is that we don't even have it.
Your Honor, wait 1 second. I'm going into the history of the May 22nd, 2019, Your Honor.
There was a criminal responsibility done?
That's correct.
Okay,
I can send that to the court.
would you please?
I will.
Thank you.
And we will hold in abeyance the first request for an evidentiary hearing having to do with,
Yes, well, we can't do any of that if we don't know if the defendant is competent.
I understand it, so it will be held in abeyance.
Anything else?
Am I correct in that motion for evidentiary hearing?
Mr. McWilliams, the court hasn't ruled on it, so it's yes.
Thank you.
Anything else from the parties?
Not from the people.
Likewise from the defense, Your Honor, and I thank you very much.
Okay, thank you.
Bye-bye. Have a safe weekend.
You too. And you too, Mr. Fickling. He said he was gonna send the order. Okay, what is ready now? Oh, I'm sorry. The court has got to leave. So we will be back at 2:00. Everybody that's on this call, your matter is adjourned until 2:00.
Ms. Hinderline,
I think she's gone. What do you need from her?
she has to send an investigation report for that.
Well, for the, it was another plea. Oh, okay, all right, get her number and then call her.
Yeah.
Or send her an email. All right, the rest of the matters are adjourned until 2:00.
Your Honor or Madam Clerk, is this personal docket at 2:00?
Yes, it's still my same docket.
Thank you.
Thank you. You cannot smoke, whoever that is on the iPhone. You cannot smoke in court.
Sorry, I didn't. I just woke
That's
up. All right,
okay, we'll see you at 2:00.
2:00.